Oke. Tes, oke. Assalamualaikum, Shalom, Om Swastiastu, Namo Buddhaya, dan salam kebajikan. Good morning, everyone. Before we start International Visiting Lecture today, we would like to welcome the Vice Rector of Student Affairs and Cooperation, Dr. Rerpol Iyat Veda Rimrosa Sitepu, SSMA, the Dean of Law Faculty, Dr. Hendri Jayadi Panjiangan, SHMH, the Head of Law Faculty Program, Dr. R.R. Ani Wijayati, SHM Hum, our moderator for today, Dr. Manotar Tampu Bolon, SHMA MH. We also would like to thanks for all the lecturers that participate for today, and the last but not the least, our distinguished visiting lecturer, Dr. Anish V. Pillai, LLM, PhD, SET from Cochin University of Science and Technology, Cochin, Kerala, India. Before we continue our lecture today, I would like to lead our prayer today in Christian. The others can adjust. Let's pray together. Dear God, help us to focus so that we can embrace our learning today. Bless us as we study, and come give those who teach us your love and protection. Amen. Now that we already finished our prayer, we would like to continue this lecture. All participants, please stand up because we will sing Indonesian National Anthem, Indonesia Raya. Now, we will continue by singing Indian National Anthem, Jana Gana Mana.
जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Participant, please remain standing because we will continue to sing Uki Anthem, Mars Uki.
Universitas Kristen Indonesia, Universitas kita, pelambang universitas kita, pelambang ilmu dan budaya bangsa, turut membina pendidikan kita. Dan kami mahasiswa-mahasiswinya bersama mengajar ilmu dan cita-cita, mengabdi membina nusa negeri kita yang jaya.
And lastly, we will sing the Faculty of Law anthem.
Fakultas Hukum Universitas Kristen Indonesia, terlahir terdidik berintegritas dalam menegakkan keadilan, berdasarkan Pancasila dan Undang-Undang Dasar 45, di bawah naungan Bhinneka Tunggal Ika. Fakultas Hukum Universitas Kristen Indonesia menetaskan putra-putri terbaik, selalu siap sedia berbakti, mengabdikan diri kepada masyarakat Indonesia demi peningkatan kualitas hidup masyarakat. Fakultas Hukum Universitas Kristen Indonesia, profesional, berkualitas, berkesinambungan. Fakultas Hukum Universitas Kristen Indonesia, satu untuk semua. Mari menjalin persatuan, melayani bukan untuk dilayani. Fakultas Hukum Universitas Kristen Indonesia menetaskan putra-putri terbaik, selalu siap sedia berbakti, mengabdikan diri kepada masyarakat Indonesia demi peningkatan kualitas hidup masyarakat. Fakultas Hukum Universitas Kristen Indonesia, profesional, berkualitas, berkesinambungan. Fakultas Hukum Universitas Kristen Indonesia, satu untuk semua. Mari menjalin persatuan, melayani bukan untuk dilayani. Mari menjalin persatuan, melayani bukan untuk dilayani.
All the participants, please be seated because we will listen to the opening speech from the Vice Rector of Student Affairs and Cooperation, Dr. Erpol Iyet Veda Rimrosa Sitepu, SSMA, virtually. Okay, thank you for the remark speech. Now we will listen to the opening speech from the Dean of Faculty Law, Dr. Henry Jayadi Panjangan, SHMH.
Thank you very much for the master of ceremony today. Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Rahayu untuk kita semua. Great for us today. Thank you very much for Dr. Anes Pillay. You can hear my voice clearly, sir? Dr. Anes, you already joined to us in the seminar?
Yes, I'm ready. Thank
Okay.
you.
Thank you very much. Nice to see you again, sir.
Thank you.
The last we communicate with the handphone, right? Okay. This is honor for us today. We make a seminar, visiting lecture in a topic, the legal ethic, the lawyers and legal profession. And today, join with us our lectures in the Faculty of Law, sir. We have the head of the study program in Faculty of Law. Her name is Ibu Ani Wijayati. Okay, and then all the lectures in Faculty of Law today may be present in our seminar today. This is honor for us that the Dr. Anis can be speech today, share his knowledge to us about the legal ethic, lawyers and legal professions. So this is a good event, I think, because we can share about the legal knowledge. How about the Indonesians' legal knowledge as lawyers, and then about the international lawyers? Because I read your CV, Mr. Anes, you are as a lawyer too, right?
Right.
Okay. I know that the students may be next for the future. You want to be a lawyer. Okay. Maybe you have a destination, the international lawyers. So please, today, this is our opportunity. You can discuss, you can share about the international lawyers matters. Okay? And then don't forget, turn on your social media. Publish this event, this seminar to the public. The Faculty of Law or University Christian of Indonesia have a seminar, have an international seminar today. Okay? And then this event is in commemorations of 75 years our university and 65 years our faculty. So I think this is a great event. The last say, I would like to say, enjoy the seminar, and then please join the seminar is properly. Thank you very much. God bless you all. Assalamualaikum warahmatullahi wabarakatuh. Om Santi, Santi, Santi Om. Tuhan memberkati.
Thank you for Dr. Henry for the remark speech. Now that the lecture will be continued by our moderator, Dr. Manutar Tampu Bolon, SH, MA, MH. The floor is yours. Oh. Okay, I'm sorry. Before we continue our lecture for the day, we will listen to opening speech from the Vice Rector of Student Affairs and Cooperation, Dr. Erpol Iet Fedarim Rosasi Tepu, SSMA.
Very good morning to you all. My name is Yet Feda Sitepu. I'm Vice Rector for Student Affairs and Cooperation of Universitas Kristen Indonesia. It's been a pleasure for me to stand here before you to give an opening remarks on behalf of the Rector. I would like to express my appreciation to Dean, Dr. Henry, and also head of the study program, Ibu Ani, and also our former Vice Dean, Ibu Eli, Ibu Dewa, Prof. Paison, and my other colleagues. I also see Dr. Manotar here. So students also, I'm really delighted to be here to deliver the speech of the Rector. Before I begin my speech, the Rector has told me to come here to represent him in delivering his speech. He is unable to be here in person due to other engagement he is having at the moment. But I'm sure that you will all be having a great time in discussion, and also hopefully networking among you. So this international visiting lecture, we are very delighted to have Dr. Anish Pillai from the Cochin University of Science and Technology, Kochi, Kerala, India. And thank you very much, sir, for your time today, although it is organized in a hybrid form, but I'm sure that the results of this lecture will not be in vain. So Universitas Kristen Indonesia is one of the top universities in Indonesia, which has already achieved its Unggul accreditation, or excellent or superior. And the Faculty of Law is one of our faculty, the flagship of Universitas Kristen Indonesia, with also the similar Unggul accredited. So through this academic meeting, lectures, seminar, and conference, we would really like to take the Faculty of Law into a higher level, in international level. The Faculty of Law of Universitas Kristen Indonesia has many collaborations with international communities, especially in legal affairs. So I hope that this meeting, this lecture, will also provide our students with wider understanding of what a legal ethic is about. So this visiting lecture is entitled Legal Ethics, the Lawyer and Legal Professions, which is very, very important for our future lawyers who are now studying at Universitas Kristen Indonesia. So I wish you a very fruitful meeting, everybody, and hope to have future lawyers with legal ethics in the future, our graduates. Thank you very much.
Thank you, Ma'am Iet, for the remark speech. Now that the lecture will be continued by our moderator, Dr. Manotar Tampubolon, SHMA, MH. The floor is yours.
Oh, all right. A very nice morning. So thank you very much, our moderators. Thank you, organizing committee. Thank you, Dr. Anis, my friend. How are you?
Thank you.
Welcome to the Faculty of Law.
Thank you. Thank you. Thank you.
Are you ready to deliver your material?
Yes, yes, sir. Yes.
All right, nice. Uh, Before we start, I will let you brief CV of Dr. Anis. Dr. Anis is a PhD holder from Cochin University of Science and Technology, Kerala, India. He obtained his double degrees, Bachelor of Arts and Bachelor of Law or LLB from Mahatma Gandhi University in India. He is also a holder of Master of Law program or LLM from Cochin University. He is a lawyer, member of the Indian Bar Association. So now, Dr. Anis, this is very interesting topic, I think, legal ethic, the law and legal profession, not only for our participant here, but also on site, but also our participant who are now attending this international lecture series via Zoom. Terima kasih buat peserta yang mengikuti international lecture series ini dari Zoom. Kami dari panitia. So now we start from Dr. Anis. We'll give you 35 minutes to deliver your materials, and then we have 35 minutes for Q&A. So, Mr. Anis, the floor is yours. You
Thank
have
you.
35 minutes
Thank you.
to
Thank
deliver your
you.
material. We must be strict on time. Thank you
Yes,
so much.
I will. So let me share my screen. I hope my screen is visible to all. Right? My screen is visible and I'm audible properly.
Yes.
Yeah. Well, a very good, warm, good morning to all of you. So today, I'm very much honored to be part of this international lecture series. This is the second time I am participating for such a wonderful event. Well, I will be discussing on legal ethics for lawyers. We all are studying law, researching law, and ultimately we are all lawyers. Those who are studying law, they will be looking for joining into the legal profession. And those who are already joined in legal profession, both these categories of people are supposed to keep in mind the ethics of the profession. Any profession requires an ethical conduct of the members of that profession. Because ethical conduct is very essential to maintain the dignity and worth of that particular profession. So that is the starting point of my discussion. So I will explain to you what are the ethical aspects of legal profession. As an introduction, I will just clarify you what is ethics. Because when we talk about legal ethics, people will have a confusion. What is, after all, ethics means? So in simple terms, ethics is a standard or an expected way of behavior wherein one person has to exercise or show that standard while he is dealing with others. So when you follow the ethical standard or ethical behavior, one can ensure that their conduct will not adversely affecting the interest of his profession, as well as the interest of the country, most importantly, the interest of his opponents and his other people. So that is the significance of ethics and ethical conduct. Now, when we apply ethics to legal profession, we all know legal profession is one of the noble profession in the world. And that nobility of legal profession comes from the ethical conduct of lawyers. So what is legal ethics? It is nothing but certain standards or certain norms. As a lawyer, you have to keep it in mind and you have to include in your day-to-day relations with others. So those standards, norms, we can call it as legal ethics. So that is what legal ethics. Now, there are several definitions for legal ethics. For an academic point of view, those who are interested, you can read. I have shared this material with your moderator, so you can collect it from him. Now, coming to professional ethics. So I said, what is ethics, then legal ethics. Now coming to professional ethics. Professional ethics of a lawyer, that is nothing. Again, certain rules and standards or norms or principles which a legal professional or a member of legal profession has to follow or has to include when he dealing with or when he practicing that particular profession. So that norms, rules, or principles, we can collectively call it as professional ethics of lawyers. So that is what professional ethics of lawyers. Now, why we need professional ethics? Being a lawyer, why we need to focus on professional ethics? Why we need to include the ethical norms in our conduct? The reason is simple. As I stated earlier, legal profession is not a business, but a noble profession. So we, the lawyers, are supposed to uphold the dignity and worth of legal profession. And how you can ensure or how you can uphold the dignity, that is by following legal ethics. Now, again, being lawyers, we are actually advisors of judiciary. In fact, the lawyers are giving advice to the judiciary so that judiciary can uphold legal justice, because lawyers will suggest the exact or appropriate legal principles, statutes, international instruments, etc. So based on that, judiciary will be able to deliver legal justice in a more fruitful manner. So our conduct must be based on professional ethics. Secondly, the future of the country depends upon the maintenance of the justice. We all know a country where there is no absolute justice, legal justice, country can't progress. Now, how to ensure justice in a country, the role of lawyers is very high. So if a lawyer is ethical in his profession, if he acts with all professional ethics, then he can definitely uphold legal justice. Then a lawyer must be, when we compare with another person or a layman, a lawyer is expected to show high standard of values, high standard of dignity. And what helps him to become a fit and proper legal professional? That is legal ethics. So by following proper professional legal ethics, one can become a fit and proper person, or one can become a fit and proper lawyer or member of legal profession. Another advantage of having legal ethics or professional ethics, that is, it will protect the public interest, because lawyers are directly dealing with the issues of public. So when lawyers include, or when lawyers approach us with ethics, or when they serve or provide their professional service with ethics, that will be beneficial to public, because ultimately they are dealing with the public interest. So we need professional ethics. And finally, as I said, to maintain the dignity of the legal profession, we have to practice legal ethics or professional ethics. Now, the need for professional ethics in legal profession is very beautifully summarized by Chief Justice Marshall. I quote, "The fundamental aim of legal ethics is to maintain the honor and dignity of the law profession, to secure a spirit of friendly cooperation between the bench and bar in the promotion of higher standard of justice, to establish honorable and fair dealings of the counsel with his client, opponent, witness, to establish a spirit of brotherhood with bar itself, and to secure that lawyers discharge their responsibilities to the community generally." So this one paragraph statement given by Chief Justice Marshall beautifully highlights the need for, or the significance of, professional ethics in legal profession. Now, when we talk about professional ethics, it has different components. That is, professional ethics or legal ethics towards court, legal ethics towards clients, legal ethics towards opponent parties or opponent lawyers, legal ethics towards the legal profession itself, then legal ethics towards the self, then legal ethics towards society. So these are the components of professional ethics. Now I will explain to you in very brief what are these professional ethics. Let's start with duties of an advocate or lawyer towards court. There are large number of duties. Just I will highlight one or two. The remaining you can read from the slide. First of all, he should act in a dignified manner. Being a lawyer or advocate, he should not indulge in those activities which will interfere or tarnish the dignity of legal profession. Secondly, he should always respect court and judicial officers. You may have different opinion. You may have quarrel with certain decisions, but you can file appeal and other legal measures, but you should not show disrespect to the court and judicial officers. Another most important duty in this regard is, as a lawyer, you should not try to influence the judge or judicial officers by visiting personally. That is very important legal ethics towards the court. Again, he shall be punctual. The punctuality is one of the essential mark of legal ethics. Then dress code. As lawyers, we have a proper dress code. So we have to follow that prescribed dress code. Then he shall be fair and frank in legal proceedings. There is a saying, lawyers are liars. I don't believe that that statement is correct. Why? Because we are not liars. What we actually do, we interpret the law, we will identify the loopholes of law, and we will present before the court. Convinced by our presentation, the court will either acquit the accused or convict the accused. So in reality, we are not lying or we are not committing any fraud with court. We are only using the legal provisions. So in that sense, we are not liars at all. But unfortunately, there may be some lawyers, they will indulge in this type of fraudulent activities. So being a good legal professional, you never try to show any unfair means before the court. Then he shall not indulge in any fact which he knows to be false in the pleadings. Same thing. Whenever we are submitting any written documents before the court, as a lawyer, we should not submit any wrong information. Knowingly, we should not submit any wrong information. Then he should not ask any adjournment for cases without any genuine reasons. Because one of the major issues our judicial system is facing is delay. There is a long delay in deciding certain cases. In the most cases, we can say the reason is a lawyer, because the lawyers will seek adjournment without adequate reasons. So that is another duty. Then he shall not interrupt when the counsel for other side or the judge is speaking. Again, being an ethical legal professional, we should give the opportunity to others, the opponent, to speak, and we should listen them carefully. Then we can give our reply. Now, when it comes to ethics towards the clients, being a lawyer, there are so many ethical aspects, or there are so many ethical conduct a lawyer is supposed to show towards his client. Like, he should accept a case in the courts or tribunal where he is normally practicing. When a client approaches me, I don't have the liberty to say, I will not accept you. If I am a practicing lawyer before the civil court, those who comes with civil cases, it is my ethical duty to accept that particular case. If I have sufficient reasons, I may reject, but otherwise, I am supposed to accept. My professional ethics requires that. Again, he shall not withdraw from a case which he already accepted. Being a lawyer, once we accept a case, it is our bounden duty to continue with the case. We should not withdraw without any adequate reasons. Again, if you are, that is, a lawyer, may be called as a victim, witness. In such cases, he should not act as a lawyer. That is, he can simply say, I may be called as a witness in this case. Because of that, I will not accept this case. Then, whenever a client approaches a lawyer, the other side, the respondent side, may have some connection with this particular lawyer. Like when a client approaches me, the opponent party may be friend of me, or I may have some connection with that opponent party. If that be the case, I should very clearly explain to my clients, see, the opponent party is my relative or my friend. And if possible, you can approach another lawyer, because otherwise there is a chance of bias. So to avoid that bias, I am supposed to disclose all informations about my connection towards the opponent party. Again, another important ethical conduct, that is, the lawyer should be fearless. Once a client approaches you, if you accept his case, it is your bounden duty to uphold interest of your client. You can't go back. You are not supposed to fear anyone. Fearlessly, with courage, we are supposed to present the case before the court. Likewise, we have large number of duties. I'm not going into the details of other duties, but these are various duties, ethical duties. a lawyer is supposed to show towards his clients. Yeah. Now, one or two, three other ethical duties I will highlight in connection with the client. Whenever a client approaches you, being a lawyer, being an advocate, you are supposed to give very honest advice, that too in good faith. Because when a client approaches and narrates the case or the story, you know very well whether this case will lead to any result, whether this case will end in positive to the client. If you know that, you are supposed to disclose. You should advise him properly. No need to go for this case because it will not give you any benefit. It's a wastage of money. So it is an ethical duty of a lawyer to give honest advice to his client. Again, once you accept a case, it is our bounden duty to prepare the case with proper care and skill. Whatever be the case, we have to prepare well before appearing to the court. And we have to present the case in a very structured and beautiful, intelligent way to the court. Then only court will be convinced with our arguments, and that will provide benefit to the clients. Then the documents. It is our ethical duty. Whatever documents are there, which is helpful for our client, that has to be submitted before the court. So like this, number of duties are there. And one more duty is with respect to the collection of fees, because we are providing our professional service. So naturally, we can collect the fees for the service we are rendering. Now, when we are prescribing or when we fix the remuneration, we have to take into account the financial position of the client. So based on the financial position of the client, we need to fix the remuneration. Now coming to the various ethical duties towards our opponent party. Being an advocate, a lawyer, there are so many duties. Like, we shall not communicate or negotiate with our opponent party without the direction of the client. Because once we start a proceedings accepting a client, we are competitors. We are competing each other. So we should not go and discuss the matter with our opponent, because that will lead to some negative impact, or that may cause loss to our client. So that is our primary ethical duty. Okay. Then we should not give whatever promise we are giving to the opposite party. Being a lawyer in the court, we have to fulfill. Then there should not be any unfair and malicious tactics. In order to win our case, being a lawyer, we should not use those unfair and malicious tactics. Then abuse of rules. As we know, lawyers are very good in manipulating legal provisions. But our ethical standard or ethics requires that we should not manipulate the rules and evidences, because that is against the dignity of our profession. Then baseless allegations against the reputation of opponent or his witness, or don't try to harass the opponent party. Then concessions. Whenever a case trial starts or trial continues, our opponent party may seek certain concessions based on their convenience. So we should be very generous to accept their request. If there is proper reasons, we can reject, but otherwise we should try to accept, generously accept the request from our opponent parties. Now coming to ethical duties towards profession. Being a lawyer, you have several duties, ethical duties towards your profession. First one is we shall not speak ill of the profession because we are the persons representing legal profession. So we are not supposed to undermine the value of legal profession through our words. Secondly, we should not discuss any matter before the media, especially newspaper and other medias, with respect to a pending case or appeal. Then advertisement. Being a lawyer, we are not supposed to solicit cases through advertisement, because if we start advertising, that will undermine the value and dignity of our profession. That may lead to several unfair practices. Then, whenever a lawyer is appearing before the court, he shall not act or plead in his professional capacity before any officer of the state, not exercising judicial or quasi-judicial powers. So that is another important ethical duty, because we, the lawyers, being the professional, we were supposed to appear before the concerned forums only. Then we shall not appoint intermediaries for procuring cases and provide some commission. So on commission basis, we should not appoint anybody to procure cases. Then another duty is, as a lawyer, we shall not entertain or show any undue hospitality to any particular judge, because that may provide some biased decisions. So likewise, we have number of duties towards our profession. And one more important duty I will highlight here, that is, being a legal profession, we have a prescribed dress code. Now, we can see these lawyers, some lawyers, they may use this gown, robes, etc. while they were traveling in public transport system. But I would say that is one of the very, very bad practice. We never use our prescribed dress code. We should use our prescribed dress code only in the court proceedings, not in any other place. Then, being a lawyer, we have several ethical duty towards ourselves, because we are representing the interest of public. We need to provide the best service to our clients. So what is required to provide best service? The first and foremost duty, ethical duty towards ourselves, that is systematic study of law and acquire up-to-date knowledge in law. Being lawyers, our study does not end by obtaining legal degree. The law is very flexible. It changes every now and then, depend upon the need of the society. So we have to know what are the changes, what are the updations, amendments, judicial decisions coming in this field, in our field. So we have to have up-to-date knowledge of law, and we have to study law. That is very primary concern, very primary duty of a lawyer towards himself. Then he shall exercise prudence and diligence in all his activities. Then he shall never be party to anything which he know to be wrong. So being a lawyer, we have to go away from all those activities which would amount to violations of law. Further, being a lawyer, it is our primary duty to discourage vexatious or groundless litigations. So we should not promote any sort of vexatious or groundless litigations. Then, rather than judicial settlement, we should try compromise between the parties, because parties are the best persons to know their needs. So we can encourage, or we should encourage the parties to settle the dispute through negotiations by themselves. Another important duty towards himself, that is, as a lawyer, we shall not indulge in any act which amounts to professional misconduct. In every country, the concerned regulatory body of legal profession have created a professional code of conduct. Now, in your country also, there is a professional code of conduct. When you join in your bar as a lawyer, you should ensure that your activities are not going against the professional code of conduct. And you should ensure that your activities are fully in accordance with the code of conduct set by your regulatory authorities. If it goes against that, that activities can be termed as professional misconduct. And most of the code of ethics provides a penalty or punishment for committing professional misconduct. So I would advise everyone to be very careful in your activities, professional activities, because it should not amount to professional misconduct. Then another important duty is he should not do anything which undermines the value of the court, that is contempt of court. Then finally, he must be fair and honest in all his dealings. At least to our conscience, we should ensure that what we are doing is fair and honest. That is, this ethics requires. Then, being a lawyer, we have number of colleagues in our legal profession. So our ethical standards or professional ethics requires that we should show a very good concern towards our other party, our other colleagues. Like an advocate shall not enter appearance in any case in which there is already an advocate. Suppose a lawyer is already there, we are not supposed to interfere because it is his case. That is a minimum ethics we have to practice in towards our colleague. Then he shall not solicit by advertisement. Then he shall not allow his name to be used by some other person for unauthorized practice of law. In certain countries, there are people practicing as a lawyer without having adequate proper legal education. They are practicing in the name of some persons who are already obtained law degree. So that should not be done, or that should not happen. Then you shall not accept any fees which is less than the fee chargeable under law. We know everyone is working for remuneration. Everyone is service oriented. Now, there may be a set standard of pricing or fee. Being a lawyer, you shall not charge less than that, because if you start charging less than that, your colleagues are compelled to reduce the fee. If that be the case, they may suffer loss unnecessarily. That will create problem. So as a lawyer, it is our duty or ethical duty towards the colleague shall not accept a fee less than the fee chargeable under the normal scenario. Now, all these duties, whatever ethical duties I have identified, are internationally known as 10 commandments of advocates. 10 commandments of advocates. So all the ethical duties of a professional, of a legal professional, we can put it under 10 headings. And these 10 headings are sufficient enough to cover all the ethical norms, rules, etc. created in different countries. So what are those 10 commandments? First one, protection of the interest of the client. So our primary task in legal profession, or when we are practicing as a lawyer, is to protect the interest of our clients. That is our primary task. Secondly, we have to properly estimate the value of our legal advice. Thirdly, we must be honest and respectful towards court, judicial officers, our opponents, our colleagues. We have to prepare the case well. We have to systematically study the law. We have to have up-to-date legal knowledge while dealing with a case. Then service. We should consider our service, the lawyer's service, as very important service because we are advisors of judicial. Loyalty to law and justice. We should always respect the law and we should always uphold legal justice. Then fellowship. We have to create a sense of unity. We have to create brotherhood among others in our profession. Then fairness in our dealings, be it a dealing with the client, be it a dealing with the court, be it a dealing with the public, be it a dealing with the government, be it a dealing with your colleagues. We have to show at most fairness and good faith. Then systematic study of law, prudence and diligence. In every case, we should show at least a minimum standard and diligence while dealing with that case. So these are the 10 commandments of an advocate or lawyer. If you clearly follow these 10 commandments, we can say you are practicing as a lawyer with proper professional legal ethics. Now, coming to Indonesia, for curiosity, I just referred your legal system to understand what are the ethical standards or what are the ethical points mentioned in your country. So I could see that there is a law number 18 of 2003, which provides the basis of legal ethics in your country. I think you might be knowing much more than me about this, but still, for the sake of discussion, I have put all these things in my material. So law number 18, in its preamble itself, or it says an oath. A lawyer has to take an oath before entering into the profession. So based on that oath, based on the preamble, based on the provisions of this law number 18 of 2003, there are so many ethical duties which needs to be practiced by a lawyer. So whatever ethical principles I have stated in an international level, whatever I could see that I have explained. So same thing is applicable in your country also, though it may be expressed in a different language or different way. Then I could find there is a code of ethics for advocates, which is there from 2002 in your country. There also the code of ethics provides what are the various ethics or ethical standards a lawyer has to follow while he is dealing with his opponents, towards himself, court, etc. I think it is divided into several headings like ethical rules regarding personality of an advocate. That is, being an advocate, what are the ethical duties you have to follow? Then we have ethical duties towards the client. While dealing with a client, what are the various ethical duties one has to follow? Then ethical duties while handling a case. What are the various ethical duties while handling a case a lawyer has to follow? Then what are the various ethical duties towards legal profession itself? So all these things are very beautifully discussed in your code of ethics. So I am sure in your syllabus, you may be studying this code of ethics in detail. So even otherwise, you can go through the code of ethics. It is available in online, maybe available in your library too. So you can read that. Now, coming to the last part of my discussion, I said ethics is something, a code of conduct, which you need to keep it in mind or which you need to include in your relations with client, etc. Now, in every country, the government is well aware that there are lawyers, they may not consider legal ethics while delivering their service. So that compelled the governments or the concerned regulatory bodies to come up with certain consequences for violating the ethical standards. So in every country, you can see certain punishments provided in their code of ethics for violating that code of that standards prescribed in the code. So what are the consequences for violating the ethical code? Generally, in most of the country, I could see there is an ordinary warning. If it is a small mistake or if it is one time, then an ordinary warning will be the punishment. And if he is repeating it, or if the violation is of serious nature, a stern warning of temporary suspension being given. Temporarily, he will be suspended from the legal profession. Now, again, he repeats and he commits very serious professional misconducts or violations of ethical standards. Then the concerned regulatory association or regulatory body can dismiss the lawyer from the legal profession so that he may not be able to practice as a lawyer anymore. So these are the consequences of violating legal ethics. So with this, I would like to conclude. I think I am well within the time. If you have any query, you can ask. I will be happy to explain. Thank you. Thank you for giving me this wonderful opportunity. So I'm expecting some questions from audience.
Sorry, Dr. Anis. Thank you so much for your very great presentation about legal ethic, especially in legal profession or lawyer. Okay. So now we go to Q&A session. We divide into 4 sessions. The first session, we have 4 questions. Ya, ini Dr. Anis sebenarnya menjelaskan, I translate to Indonesia ya. Sebenarnya Dr. Anis ini menjelaskan bagaimana seorang lawyer itu dalam melakukan tugasnya ya. Bagaimana dia harus bertindak di pengadilan kepada rekan sejawat, kepada dirinya sendiri, kepada hukum ya. Itu intinya. Dan dia juga membahas sedikit di sini tentang Indonesian Lawyer Code of Conduct atau kode etik pengacara di Indonesia. Jadi ini sangat menarik saya kira. Karena di sini ada juga sebagian lawyer, dosen yang merangkap jadi lawyer, dan teman-teman di sini pun teman-teman mahasiswa nanti mungkin banyak yang memilih karir menjadi lawyer. Ya. Jadi sangat menarik sekali. Now we go to the first session. We need 5 questions for the first session. Kita butuh 5 pertanyaan dari sesi pertama. Silakan. Organizing committee. Kita butuh 5 pertanyaan untuk sesi pertama ya. We need 5 questions for the first session. Tell your name, your institution, and then your question.
Better than me, sorry. Tes check one. Okay. Assalamualaikum warahmatullahi wabarakatuh. Shalom. Good morning, Dr. Anis, Dr. Manotar Tampu-Bolon. Good morning, everyone. Okay, let me introduce myself before. My name is Cesar. I'm coming from batch 2021 of Law Faculty here in UKI. Actually, I would like to ask a question about our future as a law graduated. Somebody told me that being a lawyer looks like we are standing in the edge of our fate, while our foot is standing in heaven and the other one is standing in hell. From that matter, I know that it's not easy to become a good lawyer or any legal profession enforcement. Yes, we have a similar tradition. Indonesia and India are a development country, but we have a different culture, hierarchy, and etc. etc. So in this case, I need a second opinion from you as a foreigner. What should we do as a future lawyer to stand in our integrity? We have a moral and integrity while we are studying as a law student. We support any law principle like legal certainty, legal benefit, and justice, of course. But after we are graduated and getting involved in our society, everything sharply decreased, changing and definitely gone. Our corrupt bureaucracy is the harder part for us to confront. So what should we do as a fresh graduated in our corruption work? Thanks.
Excellent question. It's a question of several graduate students, those who are studying law. Well, being a lawyer, being a law teacher, let me tell you, the best way to excel in legal profession, being a fresh graduate, that is, you study law systematically. When I am saying systematically study law, I am sure you are all studying law in your law degree, in law classes. But along with your systematic study, you do little research and try to publish those research in journals, newspapers, magazines, etc. Now, when you publish small research articles, even in websites you can publish, even in blogs you can publish, that will give you an idea how to frame a question, how to answer a question through research. If you acquire this quality in your law studies from law school, once you enter into the legal profession as a fresher, you can excel there very fast. Because when we study law, we will study law from the legal provisions. What is the law? What is it? What are the cases? But we never try to understand what are the practical questions which may arise from that legal provision, and how to answer that practical question applying to practical scenarios that we are not studying in our law school. And that study generally a law student does only after joining in the legal profession, and it will take a lot of time to do that. So my sincere advice to all law students is that try to study law in a way applying to practical situations, or try to learn the practical application of the law rather than the statutory provisions. Okay, so if you does that, I am sure you can excel in legal profession without much trouble. And When you have this capacity, no one can prevent you. No one can undermine you. You will definitely excel. So that is the advice I can give in this particular question. I think I have answered.
Uh, Thank you, Dr. Anis. I think you already explained briefly regarding the answer for the question. Sekarang kita pertanyaan kedua, the second question.
Yes, thank you for the opportunity. My name is Oliver. I'm from law institution in Uki University. I noticed something interesting in your presentation that legal profession. Yeah, legal profession is not a business, but it's a noble profession. I think it is from my opinion is that legal profession is also part of business. So it is possibly that we are considering legal profession as a business, because as we know that people who study law open their own law office and they gain from, so we trade our service to make money. And from that, I'm asking about what part of a noble profession that Mr. Pillai means. Thank you.
Well, why we consider legal profession as a noble profession? It has a long, very long history. Very long history. What is that history? Because most of the legal systems originates from common law. During common law, initial days, lawyers were considered as very prestigious people, and they never accept fees from their clients. They do their service free of cost. This was the starting point of legal profession. Lawyers never accept any money. It was completely free. Now, there were some clients, they wanted to give money or fees to a lawyer. So what lawyers did, you know, they kept a pocket, a small pocket at the back side of their gown. At the back side of their gown, a very small pocket they stitched so that a client can put only one small coin. That is, the lawyers never accept any money. But from that point, the society changed, the countries changed, legal systems developed. Then what happened? Now, when we provide our service, when we give our legal advice, what actually we are giving? We are giving the result of our intellectual exercise, intellectual hard work. You are learning law for 3 or 5 years as a law student. Then again, you are learning law. Then when a client approaches you, you will learn the legal provisions. Then you will apply the legal provisions into the client's problem. Then accordingly, you will give legal advice. So the legal advice you are giving is a product of your hard work and intellect. When we providing that service, we can claim remuneration for that. So providing legal service by accepting fees is just like any other profession. Because of that, we could not say it is not a noble profession. Now, You may say, when we provide service by accepting money, it is equivalent to business. The problem is, or the essential difference between a legal professional and business professional is, business professional is always interested in profit. Whatever be the thing, his main aim is profit. So business is for profit, no other concern. Generally, legal profession is not the fees. The main concern is not the fees. The main concern is delivery of justice or ensuring justice to the victims. So in that sense, the primary concern of legal service is delivery of justice. That is why our legal profession is still continuing as a noble profession. But at the same time, when you provide legal service, you can definitely accept the fees. So simply because of accepting fees or accepting remuneration, we could not compare legal profession with business. The motive of both the professions are entirely different. I think I am clear in that point.
Right, thank you. Pertanyaan keempat, the fourth question, please. Your name? Rahman Jaman.
Okay, am I audible?
Yes, please.
So my question is, we all know that in India there are reservation system, right? If you look at the institution, a reservation system for under the scheduled tribes. So I think my question is that for underprivileged prospective lawyer in India, in terms of language, their economic condition, is there any reservation system for prospective lawyer, especially who came from scheduled tribes and scheduled castes during the All India Bar examination entrance? Thank you.
Yes, for everything, like right from the admissions and even for recruitment to the judicial service, recruitment to the public prosecutors, recruitment to other court officers, everywhere our country follows reservation system. In fact, we have a 50-50 reservation system. 50, suppose 10 seats are there, 5 are reserved for the special communities, this reserved underprivileged communities, and 5 are reserved for the general. So the reservation norms are 50-50. So everywhere, and when it comes to a examination, there is a different percentage that is prescribed for passing. So those who are belongs to economically, socially weaker sessions, they are having a different percentage for passing the bar examination compared to general community. So that way, our country provides special provisions towards underprivileged people. I think I am clear.
All right, thank you. The last question for session 1. The last question for session 1.
Good morning, sir. Thanks for the attention. And let me introduce myself. For the first, my name is Alfon Pratamastorus. Then I want to ask you about how if the person who in a legal profession in India do affiliation that we know it's not good for our job and it's not, it looks like not professional. For example, as a lawyer or counselor at law, we're forcing our clients to make a fake testify. What an ethic that we violated as a lawyer in India. Thank you.
Can you repeat that question once again?
Did you get the question?
No, can you repeat that?
Coba diulangi pertanyaannya.
Oh, okay. Okay. For the question is, how if the person who in legal profession in India do a violation that we know it's not good for job and it looks like it's not professional. For example, as a lawyer, we forcing our clients to make a fake testify, and what an ethic that we violated as a lawyer in India.
He's asking about how to apply the lawyer code of conduct in India. That's the question basically.
Yes. See, we have three systems, in fact, to deal with or to ensure ethical conduct of a lawyer. One is we have a professional ethics code of professional ethics created by our Bar Council of India. This Bar Council of India is the apex body who regulate legal profession in the country. So they are having a code of ethics, and based on that code of ethics, if anyone violate, there is consequences, because that violations of ethics would amount to professional misconduct. So the consequence is, first of all, a warning. Secondly, a temporary suspension or a suspension. Then finally, a dismissal or removal of his name from the bar. So these are the three consequences of professional misconduct. Now, other than this, we have a well-established system of consumer protection law. A client is treated as a consumer. So whenever a lawyer commits an unethical practice, a consumer client or a client can approach consumer commissions. We have consumer commissions to enforce the rights of consumers. So a client can approach consumer commissions against the unethical practices of lawyer. If due to unethical practice of lawyer, a consumer suffers any injury, he will get remedies through consumer commissions. Likewise, we have another set of laws that is based on the common law tort acts or common law tort, wherein negligence, tort of negligence can be made applicable to legal professions. When a legal professional performs his act with negligence or violates his legal ethics, thereby causes an injury to a client, the client can approach ordinary civil court claiming remedy. So these are the three set of regulations which addresses the unethical practices of members of legal profession. I think I'm clear in this regard.
Right. I have a question,
Yes,
Dr.
please.
Anis. How many bar association in India now? Because here in Indonesia, we have many bars association. Thank you.
In India, we have only one set of regulations. It is a statutory body created by Advocates Act 1961. That is the legislation which deals with legal profession. Advocates Act 1961. Under Advocates Act 1961, the regulatory body is Bar Council of India. It is an apex body. Bar Council of India, it is an apex body. Then our country is a federal country because we have a center and different states. So every state governments have their own state bar councils. So Bar Council of India is at the top. Then we have state bar councils. Then every state in our country is divided into different districts. So different districts having district bar associations. So we have a hierarchy of bar association. The lowest level we have district bar associations. Then from district bar association we have state bar councils. Then we have National Bar Council of India at the top. Now, again in district bar associations, depends upon the territorial jurisdiction of courts, different bar councils are there. But these are all functioning as a hierarchy way. So there is only one set of regulators, that is bar associations. And all these bar associations were based on the Advocates Act 1961 and are under the supervision of Bar Council of India, which is the apex body. That is the structure of bar associations in India. I think I am clear.
Right. All right, because there is no more question for the participant. We'll give this to the MC, please. Thank you. Anish, for your very nice presentation.
Thank you so much.
You will be here but, online. Thank you so much.
Thank you.
Okay, thank you so much, Bapak Manotar and Dr. for the kind present. So before we end today's visiting lecture, we would like to invite the Dean of the Law Faculty of the Christian University of Indonesia, Dr. Indri Jayadi Pandiangan, and also to present the certificate to Bapak Manotar as well as Dr. Anish. Foto. Okay, so before we end today's meeting, let us, for the audience in the Zoom, please turn on your camera for the photo session and alongside Indo. Dr. Anish, can you see the certificates in your screen right now?
Yes. It's
Yes,
shared.
so this is our certificates. Thank you for coming to Christian University of Indonesia. Aapka swagat hai, bahut dhanyawad.
Thank you. Thank you.
So I think we should have a photo session together in the Zoom as well as in Yeah, so participants in the Zoom, please turn on your camera. Yeah. So to conclude today's event, allow me to lead the closing prayer. Dear God, we give thanks for the opportunity to learn and grow together. We ask for your blessings upon all those who have participated in this event, from the speakers to the audience members. As we depart from this place, we pray for traveling mercies and safety for all. May we carry the lessons we have learned with us and apply them in our daily lives. Amen. So on behalf of the Christian University of Indonesia, I would like to thank all the audience and the speakers for today's visiting lecture. See you in the next event. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you. Thank you. Thank you so much.